the investigation into the Nolan Wells death bombshell. Joining us tonight, Nolan's friends' lawyers fight back. Who's telling the truth?
The official autopsy report exists. It's complete. Done. Sitting in a file inside the Jackson County District Attorney's office right now. And nobody outside that office has read it. Not the family, not Ben Crump, not the independent forensic pathologist who flew to Washington, D.C. to perform a second examination and came back with undetermined. Not the 60 witnesses who have been interviewed. Not the $125,000 reward that's been sitting out there for weeks. Not the 5 subpoenas to Snapchat and Meta and TikTok and Life 360. The state of Mississippi has finished examining Nolan Wells' body. They know what they found. The toxicology is done. The gross findings are done. The histology is done. And none of it, not one line of it, is public. I want to start there. Not because it's unusual. It's actually standard procedure in Mississippi for unnatural deaths to go to a grand jury before the autopsy results are released. The DA confirmed that publicly in a video on July 23rd. She said it herself. Every death in the county, except natural causes and non-criminal car accidents, goes to a grand jury. So the process is following procedure. But here's what I keep thinking about. There's a difference between information being withheld for legitimate procedural reasons and information being unavailable because nobody knows what it says. And right now, 6 weeks after Nolan Wells' body was found on the northwestern tip of Horn Island, most of what's being debated publicly by analysts, by commentators, by online investigators, by panels on live television is based on an incomplete picture. Not because they're doing it wrong, because the complete picture is in a sealed file. And that changes how you should evaluate everything you've heard about this case. That's what this episode is about. Before anything else, no charges have been filed in connection with the death of Nolan Wells. No arrests have been made in connection with his death. Investigators have not made a final public determination on the manner of his death. The independent autopsy found cause and manner of death undetermined, pending investigation. The state autopsy is complete but sealed pending grand jury proceedings. All individuals referenced in this video are presumed innocent unless and until formally charged and convicted in a court of law. Everything discussed here comes from verified reporting by WLOX, WLBT, NBC News, CBS News, TMZ, The Griot, The Washington Informer, Magnolia Tribune, and official statements from the Jackson County District Attorney and the Mississippi Department of Marine Resources. Now let me tell you something about the MDMR, because there's a detail in this investigation that I don't think has gotten enough attention. And it comes directly from an official government agency's own public acknowledgement. The Mississippi Department of Marine Resources, the state agency that tracked the GPS data from the boat, that responded to the sea tow call, that has been involved in the search from the beginning, admitted publicly that it inadvertently released records related to the Nolan Wells case. Inadvertently released. Those are the agency's own words, in a letter responding to a public records request filed by TMZ. The MDMR said it had previously released records in relation to this matter by mistake. The agency was subsequently notified by the Jackson County District Attorney that Nolan's death remains under investigation, will be presented to a grand jury, and that the records in the possession of the MDMR relating to this matter are exempt from public disclosure. The DA asked the agency to refrain from releasing any more protected information. Now stop and think about what that means in practical terms. Some records from the MDMR, records related to the search, the GPS data, potentially the vessel documentation, potentially the agency's own reports from the day of and the days after Nolan disappeared, got out before anybody officially said they should be withheld. We don't know exactly which records. The The MDMR didn't specify what was released or to whom. The agency just acknowledged that something went out that shouldn't have, and that a prosecutor then stepped in and said, "Stop." That sequence tells you something about the nature of the information the MDMR holds. If those records were genuinely irrelevant to what happened to Nolan, if they were purely routine documentation with nothing in them that bore on the investigation, a prosecutor probably doesn't issue a written instruction telling an agency to stop releasing them under exemption from public disclosure. You only invoke that exemption when the records are part of an active investigation that could be compromised by disclosure. The MDMR's records are part of an active investigation that could be compromised by disclosure. That's the DA's own position, in writing. Subscribe to World Crime Files and turn on notifications before we keep going. Every confirmed development in this case gets covered here with sourced, verified reporting. Now let's keep going. I want to talk about the DA's statement, because she released something on August 18th that I think deserves to be read carefully. Not quickly, not as a soundbite, but as a complete statement from the person who actually has the sealed autopsy report on her desk. District Attorney Angel Myers McElrath released a statement on August 18th, addressing public criticism of her office and the timing of the release of information in the case. She said, "As District Attorney, I do not have the same freedom to share information publicly that private individuals may have. For example, I do not have the freedom to release letters I've sent in this investigation, discuss witness cooperation, or the testing of evidence. I do not have the freedom to identify what information is verified and what information is not." Read that last sentence again. I do not have the freedom to identify what information is verified and what information is not. That's a specific thing to say publicly. It means that from where she sits, with access to the sealed autopsy, with access to witness statements, with access to whatever the MDMR released before she stepped in, she can see things that contradict or complicate the public narrative around this case, and she legally cannot say which things are true and which aren't. Which means some of what has been reported, analyzed, debated on television and in comment sections, some of it may not hold up against what's in the sealed file. And some of it might hold up exactly, but the only person who currently knows which is the district attorney. And she can't tell you. I'm not saying that to defend her. I'm saying it because I think it fundamentally changes how you should evaluate the certainty that online commentary brings to this case. The most confident voices in this conversation are frequently the ones with the least access to what the verified record actually contains. The DA's full statement also included something else worth noting. She said her responsibility to Nolan and to the community is to complete the investigation thoroughly and carefully, without compromise, supported by the evidence, and worthy of the confidence of the people she serves. She also said something that the document transcript we reviewed this week put in context in an interesting way. One panelist on a national broadcast said out loud about an unnamed source claiming to have inside knowledge of the investigation's criminal status. "I can't put that up on the stand, a little birdie told me." That's the right instinct. In a case with this much noise around it, this many anonymous accounts, this many secondhand claims, this many people with stated certainty and no documented basis for it, the only place to anchor is the verified record. And the verified record right now is incomplete because the most important document in the case is sealed. What we know, the state autopsy, is complete. The toxicology is done. Both have been sent to the DA. They will go to a grand jury. The grand jury will determine whether to bring charges. What we don't know, what the autopsy and toxicology actually say, what the grand jury will decide, when any of this will happen. Now let me talk about the forensic science, because I think there's a genuine misunderstanding in a lot of the public's discourse about what an autopsy can and cannot tell investigators, especially in a case where the body was in warm Gulf Coast water before it was found. Dr. Roger Mitchell, the forensic pathologist, who conducted the independent autopsy for the family, announced his findings at the NAACP National Convention in Chicago on July 22nd. His conclusion: cause and manner of death undetermined, pending investigation. He was specific about one of his key limitations. When Nolan's body arrived for the second examination, the lungs and throat were not present. They had been retained by the Mississippi State Medical Examiner's Office after the first autopsy. Without those organs, specifically the lungs, which are the primary tissue for confirming whether water entered Nolan's airways during the act of drowning, the independent pathologist could not make a determination about the mechanism of death. Dr. Joseph Scott Morgan, a professor of forensic sciences and death investigator who has been providing public expert commentary on this case, addressed a specific forensic question in public commentary this week that deserves a careful look. The question: if there had been a physical altercation, fists, a fight, and a body was subsequently in water for approximately 48 hours, what would you expect to find in an autopsy? His answer, given publicly, is important to understand correctly. He said that in a fist fight, you would typically expect to see discoloration consistent with bruising if there were facial strikes or body blows. You might see abraded areas over the surface of the knuckles and hands. You would look at what he calls the leading edges, the forearm, the back of the hands, the knuckles, as points of contact. And if there were facial strikes, you would look for marks on the face. He also said the independent pathologist performed what's called a coronal sectioning of the face. Multiple incisions made into the face to look at underlying tissue, and did not find anything in that second examination that was indicative of blunt force trauma. But here's the part that gets lost in how this information has been presented in some of the discussion around this case. Dr. Morgan was specifically talking about what the independent autopsy, the second examination, showed or didn't show. He was not talking about what the state autopsy says. Nobody outside the DA's office knows what the state autopsy says. There are two separate documents here. The independent autopsy, which is public, which found undetermined cause and manner of death, which was limited by missing tissue, and the state autopsy, which is sealed, which was conducted closer to the time of death, which may or may not have access to tissue that the second examination didn't have. When Dr. Morgan said the second autopsy didn't show signs of blunt force trauma, that is accurate, and based on what was available to the independent examiner. It is not a statement about what the sealed state autopsy found. Those are two different things. This is not a minor distinction. In a case where the official findings are sealed, and the public is evaluating evidence based on an independent examination that was limited by missing tissue and performed months after death with significant decomposition already present, the uncertainty is real and it runs in multiple directions. The sealed state autopsy could corroborate the independent findings. It could contradict them. It could contain information that answers some of the most debated questions, or it could contain information that deepens those questions further. We don't know, because it's sealed. And here's the thing about that sealed autopsy that I think is important to say plainly. The DA has it. The grand jury will see it. Whatever it says about how Nolan died, about whether there was trauma, about what his blood alcohol content was, about what the lung tissue showed when the first pathologist examined it, a room full of citizens in Jackson County will eventually weigh it. That room is coming. The process is moving. There has been a lot of public pressure from the family, from Ben Crump, from commentators, from members of Congress, for more transparency in this investigation. Some of that pressure is completely understandable. Christine Wansley has been waiting since July 6th for answers. She's watched a sealed file exist in an office she can't access, while speculation and misinformation has swirled around her son's name. But the DA's position, stated in that August 18th statement, is that the restraint in communication is not an effort to keep the truth from the public. It's an effort to protect the integrity of the grand jury proceeding. Both of those things can be true simultaneously. A mother's need for answers and a prosecutor's need to protect the integrity of a proceeding she will eventually use to seek justice for that mother's son. What I notice, and I think this matters, is that the DA said on July 23rd that every unnatural death in Jackson County goes to a grand jury. She's been doing it this way her entire career. That statement was made before the case became a national story, before the Congressional Black Caucus sent a letter to the FBI, before the NAACP convention, before the $125,000 reward, before any of the public pressure, which means the grand jury process was already the plan. It wasn't a response to criticism. It was the existing standard operating procedure. I don't say that to defend the investigation or to claim that everything has been handled perfectly. There are documented questions about the timeline of agency contact, about the confrontations on the night of July 4th that aren't in any official police report, about the MDMR's inadvertent release of records that they then had to claw back. Those are real and they're in the documented record. What I'm saying is that when the DA says the autopsy is sealed because it's going to a grand jury, that's not a cover story. It's the actual procedure. And it means that whatever is in that file is going to be presented in a formal setting with legal consequences. The question that Christine and Elmore have been asking since the morning of July 6th is what that file says. When does the grand jury convene? The family's attorney said publicly in a media interview that it could be within 30 days. The DA has not set a public date. When will we know what the autopsy says? After the grand jury proceeding? Depending on what decisions are made about disclosure? When will there be an official determination about whether what happened to Nolan was a crime? That's what the grand jury is for. In the meantime, here is what the confirmed record actually says, stripped of everything that's unverified. Nolan Wells was 18 years old. He went to Horn Island on the 4th of July with a group of friends. The boat they were on began taking on water from a bilge pump failure. GPS data from the MDMR, obtained by CBS News, shows the boat left Horn Island at 4:31 p.m. Nolan was not on it when it left. 2 days later, on July 6th, a National Park Service ranger found his body near the northwestern tip of the island. He was identified through dental records. The independent autopsy found cause and manner of death undetermined, pending investigation. The state autopsy is complete and sealed. Ben Crump has retained oceanic engineering experts to examine the tidal and current patterns around Horn Island and what they would do to a body over 48 hours. He has also retained audio engineering experts to analyze the full CTO call. Neither analysis has been publicly released. The DA has confirmed the case will go to a grand jury. The autopsy results and toxicology will be presented to that jury. The grand jury will determine whether to bring charges. 3 people have been federally charged with threatening witnesses connected to this investigation. The family has filed 5 subpoenas to social media companies seeking server-side data, IP addresses, login histories, timestamps for every access point on Nolan's accounts. A $125,000 reward remains active for information that advances the investigation. And Christine Wansley, Nolan's mother, said something publicly in a recent social media video that I want to close on because it's the clearest, most honest thing that's been said about this case in weeks. She said, "I am asking for answers. That is it. That is all. Not a verdict, not a predetermined outcome, not a specific person held responsible. Answers. What happened to her son? On that island? In that water? On the 4th of July, the grand jury is coming. The sealed autopsy is waiting to be presented to it. The engineering expert analyses are pending. The social media subpoenas are in process. The federal witness threat cases are moving through the system. Nolan Wells was 18 years old. He was going back to school in the fall. He would have turned 19 in August. He cooked salmon for his parents the night before he left for Horn Island. He deserves answers. His mother deserves answers. And the process that's going to produce them, imperfect, slow, frustrating from the outside, is already in motion. If you have any information about the death of Nolan Wells, if you were on Horn Island on July 4th, 2026, if you have photos or videos from that day that haven't been shared with investigators, if you know anything at all, contact the family's legal team through Ben Crump Law. A $125,000 reward is active. Anonymous tips are available. All links are in the description below. Subscribe to World Crime Files and turn on notifications. We report what's confirmed. We source what we cite. We separate the documented record from speculation every single time. This is World Crime Files. The record speaks. Every word examined. Every victim honored.